Represent Mr. Friend. This is an appeal, direct appeal as of right from the Circuit Court in Nashville on a dispute involving a relationship between two gentlemen with respect to some real property and some work that was agreed upon to be done on that property. Our appeal is primarily based on the dismissal by the Chancellor, Judge Briley, with respect to, I would like to reserve 5 minutes.
5 minutes for rebuttal.
Yes. Got ahead of myself. Until I saw the green light.
Right.
Thank you. And so on the quantum merit claim, the proof at trial was generally undisputed for all of the elements that would require us to prove to establish a quantum merit claim. These gentlemen identified a piece of property on Springfield Highway in Goodlettsville and formed essentially a joint venture. Jointly went and they bought the property. It was in Mr. Gamble's name. The agreement was that Mr. Friend was to perform certain construction work and other works on the property to improve it. It's 26.5 acres. In exchange, Mr. Friend was, Mr. Gamble was to pay for the materials and some modest living money in the amount of $1,000 a week. The testimony was originally the project was to last 6 months, and he had agreed to pay $30,000 toward this improvement. When they took the property, or when the property was purchased, and this was in 2015, the property had a 1920s, a dilapidated home on it. So Mr. Friend went to work on this property and made substantial improvements. This proof was undisputed.
Let me ask you sort of this threshold question. Your client would fall within the definition of a contractor under the Contractor Licensing Act, would he not? I mean, he's performing remodeling, and the price seems to be well over $25,000 of the cost of repairs.
I think he would fall under that.
Yeah.
I do.
So if that's the case, and we've got the Tennessee Supreme Court case, Farmer Gets Farmer, that says in Tennessee, although we appreciate that there might be some unfairness behind that, contracts between a property owner and a contractor that's unlicensed will not be enforced, and you cannot pursue quantum merit. So we've got that as a baseline.
That's true.
Under our common law. So the only recovery then, you look to the Contractor Licensing Act, and it says, well, the best you can do is expenses. So, I mean, how do we get past that?
Well, we get past it because even though if their agreement was just, hey, I'm going to build this, and here are the specs that I'm going to do, and you're going to pay me, then I believe he would fall within that line of thought with the Farmer case. The way this case is distinguished, though, is because Mr. Friend and Mr. Gamble essentially entered into this joint venture by which he was there and this property, and we actually sued. One of our claims was an equitable title. Even though the title was in Mr. Gamble's name, Mr. Friend performed this work in exchange for 5 acres on this property. And the proof at trial was the 5 acres were identified by Mr. Gamble. It was in his proof. He identified what 5 acres he was to give to Mr. Friend. So this was different and distinguishable because this was essentially a partnership, a joint venture, by which Mr. Friend was an owner, in essence. Even though not a title owner, he was an equitable owner. And so this is distinguishable because, he didn't give him a bid and say, hey, I'll do this for X amount of dollars. He just did the work, and it was funded. Another distinguishable fact was it was funded by Mr. Gamble as the project proceeded. He set up an account at Regions Bank, and when Mr. Friend, who contributed a lot of the materials himself.
And I guess Gamble paid in, what, $157,000 over the roughly 6 years?
Yes,
So,
Your Honor.
I mean, again, I keep circling back around to the notion, though, your client, no matter how you characterize the relationship between the two parties, is functioning as the contractor under the joint venture. I mean, Mr. Gamble wasn't doing the work. Your client was doing the work.
Well, except he would be distinguishable as an owner. He can, as an owner, he came in and that's how he saw it. Hey, I'm gonna work on this property, which was all part of the 26.5 acres, and the 5 acres, which was to be his compensation, was never, it was identified, not surveyed, but it was identified, and Mr. Gamble stated that and pointed it out even on a map at the trial.
But the 5 acres that your client was going to receive in compensation wasn't part of the 5 acres he was working on. He was working on a 1920s home and that pavilion.
That's true, but it was still part of the 26.5 acres,
Okay.
and it had not been parceled away. And so this essentially was a joint venture by which these gentlemen sought this project, essentially. He wasn't seen as some contractor off the street because he wasn't paid wages. There was no, in essence, there was no contract for, oh, well, I will do this for $10,000 and I'll build you this structure. And
So let me ask you this. Did you argue or present the joint venture theory to the trial court?
it's in our pleadings, and that's what the record reflected at trial.
And so you're saying then that you told the judge this is a joint venture? You characterized this as a joint venture? And my next question is, if so, what did the judge rule on that?
Well, frankly, I think the proof, I didn't bring a claim that said, it was in the declaratory judgment part of the complaint. And that's the part that had the information in there about the joint venture. We proved all the facts to show a joint venture.
So did the court rule that it was a joint venture or that it wasn't a joint venture?
He did not rule on it. He just dismissed the declaratory judgment action, and we proceeded on the unjust enrichment.
Okay.
Counsel, on the unjust enrichment here, in the end, let's say you're right about everything else, doesn't this still fall on issues of credibility? And there's a determination, essentially, the trial judge looked out and said, I believe the expert witness as to the valuation, and I don't believe your client as to valuation. And in the end, isn't this really, even if we get through all the other hoops, over all the other hurdles, don't you have a credibility problem here?
Well, I would if the trial court made his determination and decided credibility based solely on my client's testimony. But what we have is we have other facts, even those that are substantiated by Mr. Gamble, that support my client's statements and his position. Number one, there was never any challenge to the fact that he improved. He built 2 structures. One was a garage and one was a pavilion that he made into like an efficiency apartment, a 1-room apartment.
Counsel, aren't
The
we
house.
off, though, the original agreement? And Judge McBrayer's question pointing out, I think, $157,000 or something dollars, and you mentioned there was an agreement they were going to spend $30,000. I mean, it seems like we've long since left behind 6 months and $30,000 here.
Absolutely.
Well, and then we've got a very informal relationship that's underway between these parties at that point, and it's, I don't know what the agreement is beyond $30,000. I don't think there's anything in the record that indicates what the agreement is beyond $30,000 in 6 months. And this seems to be a go by the day kind of understanding these parties had.
Well, unfortunately, they didn't have lawyers involved. And so they both made that central mistake.
Yeah.
But they...
Pay me now, pay me later problem, wasn't it?
Exactly.
Yeah.
But this was a continuous relationship, although Mr. Gamble at trial said that's the agreement and the changes, the terms were never modified. Yet, over the next 6 years, he kept funding this project. and kept being involved. He was there all the time. He didn't participate, but he was on the premises on a regular basis, according to the testimony at trial. And so, but I want to address about the credibility. We have independent proof, other than the testimony of Mr. Friend, that says this property was improved. The only issue, and I want to make sure Your Honor knows, Mr. Danny Adams, who was the expert, he did not testify to the value of what Mr. Friend did. What he did was he testified to the value of what it would, or the cost of what it would take to complete the project. And I think that's an important distinction. So we have undisputed proof as to the things that my client did. He built a 320-foot geothermal system. He put in the flooring. He put in the windows, the doors, the electrical, the plumbing. He did the HVAC. He did all this. And so, you get to the question of the value, and the Chancellor, Judge Briley, had an issue with the credibility, and so he was less than persuaded as to the value, but there was value there. Now, the value we submit was the 5 acres.
Mr. Preston, your time is up, so.
Thank you, Your Honor.
We'll hear from you again on rebuttal.
Thanks.
Good afternoon. My name is Caitlin King. I'm here on behalf of the plaintiff appellee in today's case, Mr. Leonard Gamble. Now, we are here to ask the court today to uphold the lower court's judgment in Gamble versus Friend. This case concerns whether an oral contract for the sale of real property for which the terms were uncertain and the appellant did not substantially perform in some way entitles the appellant to damages beyond the benefits that he has already received. Now, just to quickly summarize the facts of this case, my client purchased this property in 2015. He hired the appellant to perform these renovations on the home. The two parties agree that they entered into some sort of oral agreement, but they disagree on the material terms. For example, my client believed that this was to be completed within 6 months and cost $30,000. In exchange, the appellant would receive 5 acres of land. The appellant disagrees that there was a timeline set. He stated that there was no timeline and that he was to receive $1,000 per week indefinitely, no matter how long the renovation process took. Notably, the 5 acres was not precisely identified, and at trial, the two parties seemed to disagree exactly where the 5 acres was. They were roughly close, but what constituted the 5 acres, they didn't really know. Obviously, the statute of frauds, for good reason, requires that the contract for sale of real property be put into writing to be enforceable.
But, here the court doesn't reference the statute of frauds in their final determination. I agree with you, that seems to be a good defense, but I'm not completely confident on what basis the court rejected the contract claim. It sounds like the court felt like the counterclaim was conceded in the submission of the findings of fact and conclusions of law. Is that what happened? And are those proposed findings of fact and conclusion of law on the record?
I would agree with your interpretation of the order there. It seemed that the lower court stated both that the appellant conceded that he did not meet his burden, and independently the court also found that he did not meet his burden.
Yeah, but so we're left to wonder, though. There's 3 elements of a contract claim. We have to guess which element. I guess we assume that none of the elements were satisfied. Is that what we're to do?
I think it's pretty clear from the record that none of the elements were satisfied, even if the court didn't explicitly state that in the order. Now, it is undisputed that the appellant lived on the property for free, not even paying for utilities, for nearly 8 years.
Counsel, wasn't that essentially not something in terms of pay or compensation, though? I mean, sort of a kindness of your client in terms of why Mr. Friend was allowed to live there, and that's not part of what he was being paid, is it?
That's correct, Your Honor. It was both a kindness and a strategic plan to allow the appellant to live there, because the appellant claimed that the materials for the renovation might get stolen, and if he were to live there, he could prevent that from happening. But mostly because Mr. Gamble and Mr. Friend were friends for many years before all of this, and yes, allowing him to live there was a kindness. However, the court found that allowing the appellant to live on the property constituted plenty of compensation for any labor that he may or may not have done. And at trial, he was not able to prove that he did any labor or purchase any materials, because he called no witnesses and offered no documentary evidence.
So in the end, if opposing counsel does, same question I posed him, if opposing counsel jumps through every other loop, at the end of the day, is this just a credibility case? The court didn't find Mr. Friend to be credible with regard to his testimony as to his expenditures, as to the value he added, and therefore didn't meet his burden of proof on that element.
Absolutely, Your Honor. This is absolutely a credibility case. The court found that not only did the appellant exaggerate his damages, at some point, the claims he was making defied common sense. And because he had no other evidence to back up his claims, the court had no choice but to rule in favor of the appellee. Now, again, at trial, the appellant testified on his own behalf, called no further witnesses, no documentary evidence. In contrast, the appellee hired an expert witness to come and evaluate the property. This contractor had a lifetime of experience inspecting and building homes, and the court found that this expert witness was very credible. This expert testified that not only was this project not even close to being completed, much of the work that the appellant did do, or potentially did, needed to be completely scrapped and redone, because he did so negligently. He testified that any reasonable contractor would put a roof on the house and close in the house before putting in things like drywall, insulation, electrical, because if you leave those things exposed to the elements, they will get damaged, and that's exactly what happened in this case. The work that the appellant claims to have done was left open to the elements for years and years and completely ruined. So this project is going to cost my client, according to this expert, $172,000 more than he's already spent, on top of the $157,000 that he's already expended renovating this property. I would argue that that is absolutely evidence that the appellant did not substantially perform under this contract. Now, at trial, the appellant pursued a joint venture claim, and this joint venture claim was summarily dismissed by the trial court. The court found that he did not meet his burden of proof to prove that there was any sort of joint venture, and therefore it was dismissed. Regarding the standard of review, Wood v. Starco requires the court to conduct a de novo review of the trial court's decision with a presumption of correctness to the lower court's findings of fact. The findings of fact that the lower court did make were that appellant's testimony was not credible. He provided no other proof to prove his claims or the value of his proposed damages. That the expert's assertions were credible, and that the benefit of living on the property for free was plenty of compensation for any work he may have done.
Counsel, do we know from the record how the $157,000 was spent? Whether was it spent all on materials? Was it spent on labor? Was it spent on? Do we know how the $157,000 was used in this case?
No, Your Honor, that was not made clear in the record. It seems that it was a combination of materials spent and payments made to the appellant.
So there's some degree of compensation in the $157,000, but we don't know how much, essentially.
Absolutely, absolutely. The appellant received $1,000 a week for several weeks. I don't recall exactly how many. I believe it was somewhere around 6 months, which was the original agreement. Beyond that, it's not clear exactly how the appellant spent that $157,000. Now, these findings of fact that the trial court made, this court must presume that they are correct because there is no evidence to prove otherwise. No witness testimony and no documentary evidence. And because these findings of fact were made, to even assert that they were made in error under these circumstances with no evidence whatsoever is entirely frivolous. For this reason, not only are we asking the court to uphold the lower court's ruling, we are asking the court to award damages to the appellee for the nature of this frivolous appeal, which is permitted under Tennessee Code annotated 27-1-122. The court in Wallen v. Marshall held that an appeal is frivolous when it has no reasonable chance of success or it is so utterly devoid of merit as to justify the imposition of a penalty. In that case, the appellee owned a piece of property which was sold at a tax sale. Now, the county did not issue proper notice to the owner of the tax sale. So at trial, the owner pursued a motion for summary judgment, which was unopposed, and it was granted. Now, the purchaser, who was the appellant in that case, subsequently filed a motion to set aside this order approving the motion for summary judgment. This motion was also denied. Then the appellant appealed that order to the appeals court. And when the appeals court reviewed the lower court's findings, they found that not one piece of evidence was offered to prove that the appellee did in fact receive proper notice. And because of the nature of the frivolousness of this appeal, the court not only upheld the lower court's ruling, but actually awarded damages to the appellee in the form of attorney's fees and expenses. Similarly, here, the burden of proof was on the appellant to prove his damages and his claims, and yet he did not offer a single piece of evidence or a single piece of proof into evidence, whether documentary proof or testamentary proof. And
Well, he offered his own testimony.
other than his own testimony, correct? Yes, Your Honor.
Well, I mean, sometimes that's all you have. So, I mean, I don't see this as the same case as the frivolous appeal case. I mean, there was some proof offered. It was just the trial court didn't accept it.
And he did not appeal based on the trial court's not admitting that evidence or that proffered evidence into evidence. With no documentary or unbiased testimony evidence whatsoever to prove any of his claims, and with his testimony having been found not credible, the lower court had no choice but to dismiss appellant's claims. And to even contest this holding is absolutely frivolous. For the reasons above, we are asking the court to affirm the lower court's ruling and award damages to the appellee in the form of attorney's fees, expenses, and costs due to the frivolous nature of this appeal. Thank you.
Thank you, counsel. We'll hear from the appellant on rebuttal. I believe you have 5 minutes.
Thank you, Your Honor. A couple of things I'd like to point out. The number one, with respect, you questioned about the contractor. I would respectfully submit that that's an affirmative defense, and that was not pled at the trial level. So I think that's important in the record, that statute was not raised in the answer by the defendant, plaintiff, counter-defendant. Number one. Number two, the chancellor did in his final order state that there was value in Mr. Friend having lived on that property for the number of years that he was there. But there was no proof at trial giving value to that, nor was there any, there was not a claim for that in their complaint. So they didn't sue for value as a set-off or anything else of Mr. Friend being on the property. They sued for possession. They were granted possession, but there was nothing about that. And so for the chancellor, just to, out of thin air.
I thought there was a rent claim, though, that the judge did ultimately deny in this case in its order. It's the next to the last paragraph in the order. Plaintiff's claim for damages and attorney's fees pursuant to 66-2815-512 was denied.
That wasn't for a rent claim, though. Respectfully, perhaps I'm mistaken on that, but the writ that they sought that was appealed from did not ever seek the damages.
Well, I mean, what the court said was the evidence fails to demonstrate that it was that Mr. Friend's holdover tenancy was willful and not in good faith. So it sounds like there was at least some rent claim.
I believe that that's inaccurate, that they put on any proof or sought anything about rent. They did have the claim about a holdover because he didn't have a lease or anything, and so he was there, and so that was the claim when they brought their writ to have him removed, which was ultimately granted in there. So,
is there a clear indication from the record of how the $157,000 was spent? I mean, in terms of not being compensated adequately for the work he put in, do we know how much of the $157,000 went to payment of him for the work he did versus materials?
Well, there was discussion, and there was some proof at trial about he did hire other people, he did work, and it's important to note that Regions bank account was totally controlled by Mr. Gamble. My client had a debit card that he could use, and he could, there was record that he would buy, food occasionally and stuff like that, but there was never a wage.
If you're looking if Judge Briley looking at this, though, would he have any way of knowing whether, maybe he paid himself $80,000 out of the 157, maybe he paid himself 90, maybe he paid himself 10. Do we have any idea? Did he lay out and say that 157? Did he, even in his own testimony here? Did he say I used 80,000 on hiring other contractors? I used 20,000 in buying the drywall material. Do we have that kind of testimony here?
That testimony wasn't made at issue. When Mr. Friend talked about the use of the debit card that he used to fund the job, there was testimony about him buying, but there was no specifics as to, I spent this on hiring additional labor, I spent this. That was never challenged, nor was it made part of the record. But that I think it's important for the court to understand that account and all those transactions were maintained and controlled by Mr. Gamble. He funded it as it went along. And with respect to the order of building, the record also shows, and it's uncorroborated, that there was a funding problem that Mr. Gamble ran into. And so he tried to get additional financing to complete the job, and that's why the roof was never done, because, and the proof at trial showed, that he would not pay for what was necessary. And at different times, Mr. Friend said, hey, here's what it'll cost, and here's what we need. He wouldn't fund it. He went to go get financing, and he testified, Mr. Gamble at trial, that the reason he couldn't get the bank financing to complete the project was because he didn't have a licensed contractor. And so that is an impediment to Mr. Friend completing the job. But one thing that I think is important for the court to know is that there were pictures that were submitted by Mr. Gamble of the project and what was done. And on the one hand, they argued that, and the court, and I respectfully, this is corroborating evidence that supports Mr. Friend. The court said, well, I don't believe your testimony. But yet, they have an expert who came in, a construction expert that came in and showed through pictures, oh, well, he did this, I think that's wrong. He did this, I think that's wrong. And so there's a dispute as to, and the only evidence, financial evidence from Mr. Adams, who was their expert, was that it's going to take X to complete the job. He gave no testimony as to the value of the work done by Mr. Friend. And so, frankly, I would just go back and reiterate, or actually not reiterate, I didn't mention it, the Pascal versus Dozier case, Supreme Court case on unjust enrichment.
Mr. President, your time is up, so.
Thank you.
Thank you. That concludes the docket for today. If you will adjourn court, please.